Good morning, Mr. Polo. Welcome back. We will now continue with the cross-examination by claimant's counsel.
Good morning, Mr. Polo. Yesterday in the late afternoon, we discussed that Peru was going through a significant economic, financial, and security crisis in the late 1980s, early 1990s, when you joined the ministry as vice minister in 1990. You explained that previously you used to work at Centro-Min, and when you took up the position in the ministry, you were on loan from Centro-Min. So continuing that conversation, given the economic, financial, and security crisis at the time, would you agree that it was one of Minister Sanchez Albavera's aim to promote investments in the mining sector? Did you hear anything translated or nothing? ¿Usted escuchó algo traducido o nada?
No, nada.
Okay.
Sí.
Now I can hear the translation. I'm going to start again then.
I was just saying that yesterday in the late afternoon, we discussed that Peru was going through a severe economic, financial, and security crisis in the late 1980s and early 1990s. You used to work in the 1980s at Centro-Min, and then joined in August 1990 the MINEM as the vice minister, and you explained you were on loan from Centro-Min, so you received your salary from Centro-Min when you joined the ministry. So my first question following up on what we were discussing yesterday was, would you agree that given the economic, financial, and security crisis, it was one of the key objectives of Minister Sanchez Albavera to promote investments in the mining sector?
Yes, indeed.
Promoting foreign investment in the mining sector actually as being of national interest, right?
Yes, that's true.
And one of the ways to promote foreign investment in the mining sector was reforming the existing mining law by enacting Legislative Decree 708, right?
That's correct.
And specifically, Minister Sanchez Albavera wanted to promote foreign investment by granting investors stability guarantees, right?
To the investments, yes, correct.
And Minister Sanchez Albavera actually asked you to work on new provisions regarding stability guarantees, is that right?
That's correct.
And you described at the SMM hearing that you were working with a team of recognized tax experts, including Dr. Rubio and others. Is that right?
They participated in one or two meetings, but they were not strictly part of my team.
And you sought to broaden the existing stability guarantees to make them more attractive for foreign investment. Is that right?
To the investment projects, new investment projects, yes.
And to give you a better idea about what the new provisions regarding stability agreements could contain, Minister Sanchez Albavera sent you to Chile, right?
Yes.
And Chile had implemented a mining reform in the early 1980s, right?
It started in the 70s and then it went on in the 80s, I think.
And would you agree with me that Chile had been successful in attracting foreign investment in the mining sector as a result of that reform?
Yes. He had good success. It was interesting to know its experience.
And would you also agree that in the early 1990s, Chile was Peru's biggest mining competitor as far as attracting foreign investment goes?
It was an important competitor, apart from others.
Well, in the SMM hearing, well, it's fine. So Minister Alvera sent it to Chile to study its mining law, right?
Yes, for me to talk to the officials about the mining legislation and the attraction investment mechanisms. I also spoke to government officials and private parties.
One of the purposes of your trip was to learn about the stability regime that existed under Chilean law, right?
Well, in connection with the regime in Chile, and also I also looked at the system of investment attraction of Decree number 600. So we talked a lot about the mining sector. It's not exactly the same thing.
Well, Minister Sanchez Alvera tasked you to work on new provisions for stability guarantee. So the key purpose to travel to Chile was for you to learn how stability guarantees were handled in Chile, wasn't it?
Amongst other things, I had to look at other things as well, such as the more flexible management mechanisms for labor protections, and we did take some of those things and we adapted them to Peru. Then we also learned that there were guarantees that they afforded the investors for the money they brought in, and also for the repatriated funds for investments. I discussed this with officials from Codelco, Cochilco, Sarajemin, and the Ministry of Energy and Mines, amongst others.
So when you say entre otros, then one of the areas that you were looking at to learn from the Chilean legislation was how Chile treated legal stability, right?
Yes, legal stability, new investments that were brought in, and capital repatriations for all sectors in general. That is what I recall.
And Chile being, one of your main competitors, for you it was important that the stability guarantees that you would work on for the new Peruvian legislation would be at least as favorable as that of Chile, right?
We were not seeking to do something that was the same. We wanted to get to know them and adapt them to Peruvian law. That was a relevant thing. I had very clear idea because I had experience in projects and finances in connection with the investors.
I said, well, let's look at your first witness statement, paragraph 10.
¿Dónde está eso?
Where is that?
A folder under tab number 1. There's like a, yeah, I think the small one might actually have it as well. It's probably easier to handle. It's your the first witness statement, paragraph 10.
Sí, acá lo estoy viendo.
Yes, I'm looking at it here.
We're putting it on the screen. Just 1 second. I will read the English part. You said there to prepare the draft legislative decree, Minister Sanchez Abavera assigned me the task of proposing the new provisions on stabilization matters. Right? Faced with that important task of proposing the new provisions on stabilization matters and to have a better idea of what the regulation might contain, I traveled to Chile with the aim of studying its mining law. Chile was Peru's biggest competitor at that time in terms of mining investment, and for us, it was important that the legal regime in Peru be no less favorable than Chile's, even more so considering the circumstances that Peru was in. You see that?
Sí.
Yes, that's correct.
So what you wanted to do in order to be competitive with Chile is to have a stability regime that was at least as favorable than that of Chile's.
Better, from our viewpoint. We wanted to be better from our viewpoint. Not the same or favorable or less favorable. We wanted it to be better from Peru's viewpoint.
It's quoting from your witness statement where you said no less favorable, even more so, but better is understood. And
Sí.
in your recollection, at that time, Chile granted stability guarantees to concessions, right?
The mining law does not say that, and I looked at the mining law as well, as my statement says. The mining law does not say that there is a stability guarantee to the concession, legal stability. This in terms of what we're talking about in Peru. It provides stability. It may be an infinite concession, but we did our own thing. The Chileans provided certain stability, and this had to do with the previous history that Chile had.
Well, let me show you what Peru said in its rejoinder in paragraph 170 and see whether you agree with that. It's a paragraph 170 of the rejoinder.
¿Dónde?
And in the binder, in the binder it's tab 9.
Sí, en el nuevo, el grande.
That's a big binder, right?
Yeah, that's going to be in the big one. Sorry, it's tab 8. Tab 8 in the binder.
Está en inglés.
Is there a Spanish version or just an English version?
It's all in English, so I will read it into the record so that you get a translation of it. It says, respondent, which is the Republic of Peru here, agrees that some mining jurisdictions, such as Chile, grant stability guarantees to all concessions, and that is a valid choice for a stability regime.
No sé de qué.
I'm not sure what kind of stability they're talking about. I don't know if they're talking about concessions. So if they're talking about concessions and they cannot be canceled without a special provision, well, that's one thing. But we're not talking about administrative or tax or legal stability, and that is what we're pursuing for investment projects. The concession has a stability, and that lasts forever. It is granted by the judiciary, and it treats it in a special manner. If that's what they're talking about, then I'd agree. But I have not heard or seen anything in connection with stability, tax stability, in the Chilean mining law.
En todo caso,
I took whatever I considered necessary, and we went to the relevant things. What we were going to do in Peru, they had to be relevant.
So, Mr. Bolo, you're talking about the Law 600 in Chile?
No. In this case, if we're talking about the mining law and the concessions, well, I'm talking about the Organic Constitutional Law of Mining, which is a special law that was passed in Chile for the mining sector. It was promoted by José Piñera, amongst others. That is the mining law in Chile. I have not seen there or heard anything there that refers to the stability agreements as we refer to them here.
100 in Chile granted tax stability and other stability to concessions, didn't it, at that time?
I have not seen it or heard it like that. Law 600 was for all sectors, not only for the mining sector. Law 600 is a law for investors that bring money. It provides guarantees, and it provides also guarantees for those that repatriate capital in all those sectors. In the mining law,
Law 600 also applied to mining companies, didn't it?
it applies in a particular manner. I didn't dip into the matter. It wasn't the case. I knew the general stability provision and the guarantees that it was providing. I heard, I discussed this, I brought this to Peru, we discussed this with the minister, and we decided to do this, and that's the relevant thing.
The mining reform, Mr. Polo, that you were working on introduced a principle that's called administrative simplification, right?
That's correct.
Hay un
There is a specific title that bears that name.
The main purpose of the administrative simplification was to cut the red tape, to make the administration of stability guarantees less bureaucratic. Is that right?
In general, the purpose of it was to reduce the paperwork, reduce discretionality, and to make things as transparent as possible, and to prevent arbitrary decisions to be taken within the ministry. So there was a presumption of truthfulness. Also, we had administrative positive silence. Also, we had an external sworn statement and other aspects, and that I cannot recall at this point in time. But the proceedings or procedures rather were more agile, and we wanted to have a very transparent mechanism, as transparent as possible. Also, amparo related to labor matters that was simplified, because this brought about complications that led to corruption and discretionalities, and we took that from Chile. Chile had a different amparo for work. Chile just pays. We pay, but if there are penalties as well. So there are simpler things that we took from Chile, and that's part of administrative simplification. And the way to evidence this is simpler. We have sales settlements for $100 per hectares. So that's a simplification for mining producers. And all of the statements that we saw that are presumed truthful, we also had things under oath, and also positive administrative silence. That's what I remember. I need to drink some water. Excuse me.
Mr. Polo, one of the features of administrative simplification was also that you wanted to eliminate discretion of government officials, right?
Correcto.
That's correct.
And one of the purposes of eliminating discretion of government officials was to reduce opportunities for corruption, right?
Correcto.
Correct.
So let me show you an excerpt of a book that Minister Sanchez Ababero wrote, which is called Carta sobre la Mesa. Let me ask you first, are you familiar with the book Carta
Sí,
sobre
lo
la
conozco.
Mesa? Which
I do. Yes, I do. I have read it some time ago. I do know the book.
you have read the book before?
Sí.
Yes, of course.
Pero
I have read it.
Look at one part of it. This is in your binder in tab 3. It's Claimant Exhibit 311. It's on the screen, and you also have it in your big binder at as tab 3. If you want to look there, and the excerpt is from page 83.
It's very small on the screen. You said tab 3?
What-
Changed
esto-
everything.
el libro son
So it's better to look at it on the screen, I think.
ok. Ahora sí.
Okay, now I have it.
And page 83. And he says here, you will see, the mining reform introduces the principles of administrative simplification to expedite matters procedurally based on the presumption of truthfulness and positive administrative silence in all procedures. These principles are aimed at bureaucratizing decisions by making the administration of concessions more transparent and the supervision of mining operations more effective, which under the previous regulations lent themselves to maneuvers that facilitated administrative corruption. You see that?
Sí.
I do see that. Yes, that's correct. That's the same thing I've said.
With Mr. Albavero's statements.
Sí.
I do, yes.
So one of the features was to make the supervision of mining administrations more effective, right?
Yes, that's right.
Now, one of the features of administrative simplification was making stability agreement in adhesion contracts, right?
It's the same law, but there are two different chapters in the law. Same law, two different chapters. In a certain manner, concession contracts are a way to put things in order and avoid discretionalities. That was precisely their purpose. And this is connected to guarantees, and I think the titles are different in the law. I think one of them is Title 9, and the other one is a different title. I don't recall.
But I was not talking about concession contracts. I see that you mentioned concession contracts. I was talking about adhesion contracts, form contracts.
No. es de
You may have
adhesión.
misspoken.
Okay.
Contrato.
Adhesion contracts. Concession contracts, no, they don't exist in Peru.
There are two different chapters. What are you referring to, Mr. Polo?
Within the law, there is a title that says administrative simplification, and the other chapter talks about the benefits and guarantees. That's a different chapter. Benefits and guarantees, and I think Article 13 of 708, well, it talks about adhesion contracts. And I mentioned this in my statement in the other hearing. I said that I had brought this in from personal experience when I looked at a stability agreement, when I just sat down as the vice minister, and there's some aspects that I thought were not within the purview of the vice minister. So I realized that we had to put things in order here. The final purpose was, okay, this is what we guarantee, it is very clear, and this is what goes. Nothing can go beyond this. And the proposal was for a model to be prepared, approved by a supreme decree with the Council of Ministers vote for larger contracts, and for the smaller contracts, they were going to be approved by a ministerial resolution in a simpler manner because the amounts were lower. Mainly, it had to do with the non-discretionality in the management of the contract, because everybody had the same kind of opportunity and everything had to be approved by a law.
And so if I understood you correctly, before the mining reform contracts, stability contracts were negotiated with the government and companies had different stability agreements, but you then had the idea of making them into adhesion contracts. So that is that correct?
Let's say that I found that it was more appropriate that the guarantees section of the agreement has a number of portions, the guarantee portion of the agreement had to be adhesion, because we applied this to all cases, all the same, for equal opportunity and to have things clear. That's it.
So you would agree with me that the purpose of the adhesion contracts was to eliminate negotiations between the parties and the governments as to the terms of the stability guarantees, right?
Negotiate outside of the guarantees. That was not allowed. The agreement is not literal, fully in nature. It looks at the blanks, and the blanks have to do with the regime current at that point in time. The stability agreement has to cover this, this, and this, and this. And then you have an exhibit, which is the feasibility study that relates to the project and that was receiving the benefits, the mining investment project.
What you wanted to do, if I understood you correctly, just to be clear, was to eliminate negotiations regarding the scope of the stability guarantees. Is that right?
To guarantee whatever it was exactly necessary for investment projects, whatever was required for investment projects to have very clear and precise rules of the game, nothing else. I looked at a contract once, and they wanted to stabilize water rates and electricity rates. That's not part of the competence of the Vice Minister of Mines, and it had other things that I thought were excessive. It was very clear to me that what we had to guarantee is that the investor of the project has clear rules for a period of time, rules that are reasonable and stable, and that may allow to assess the profitability in the feasibility studies that they submitted themselves for the projects that they presented as the subject matter of the contract.
Let me show you what you said in the SMM hearing. That's in tab 3, which is Claimant's Exhibit 1137. And
tab 3 here.
Finnish version that you look at, it's 1233 1 to 5. And in the English version, 1209 3 to 7. And it said like, I asked you, and you wanted to eliminate any negotiations regarding the scope that the stability guarantees would have. and you said yes, the regime would have to be the same for anyone who met the requirements. Do you see that?
Yes, that's what I just said. It's the same thing as I just said. Yes.
Agree with that statement? Okay.
Sí.
Yes.
So, just to see what that means. So it means that the government and investor, they cannot sit down and negotiate which stability guarantees would be included in the contract and which ones would not be included, right?
That's right. The guarantees were set out in the law, what it was that was being guaranteed. It was set out in the law, and according to the model approved, and that was done under another vice minister, not me, one had to fill in the blanks, as they say, with the regime that corresponded at that particular moment in time. That's it.
And it also means that the mining investor and the government could not negotiate the terms of the stability agreement, right? They could not say, well, the law says 15, I would like to have 17, or I would like to have 12, right?
The law doesn't say 15. The law says shall have the tax rate at that time from the moment the feasibility study is approved. At the moment the stability agreement is adopted, what's the income tax rate? 30, and so it's set at 30. But it doesn't say 30 in the model contract. It varies depending on the moment when the feasibility study is signed or approved. What you can't say is, well, it's 30. Well, you know, in Chile, they give us 27. No, that could not be done. It's what the law says at the time of the feasibility study. And that is what the adhesion contract refers to for that sort of thing. It also indicates that one can review profits, and one would say, and the new government might come in and say it's convertible. It says I can freely reinvest or redo the profits.
I'm just always waiting for the translation to finish. I think you were misunderstanding me. I was referring to the length of the stability guarantees. So the stability guarantees are granted for 10 years or for 15 years. And I think that, is that correct?
Es correcto.
That is correct. You have both. It depends on the nature, particularly based on the size of the project. It's a larger one. Well, it's set out in the law. In the case of Cerro Verde, it's 15.
And that was actually one of your ideas, I understand, to simplify matters and say from now on all stability agreements will have a fixed term. Is that right?
A 10-year term for those that are more than 2 or less than 20 or 50 at the time, and for those that are more than 50, a term of 15 years.
So the mining investor and the government could not sit down and negotiate different terms. They could not say, I want to have 20 years or I want to have 12 years. Is that correct?
No, that could not be done.
And the same is true with regard to the scope of stability agreement. If the law says the stability agreements have a certain scope, then the parties cannot say, you know, I want to have a bigger or a more restricted scope, right?
What do you mean when you say scope?
With scope, I mean to what type of activities the stability guarantees apply.
The activities were spelled out by the investor in their feasibility study. The feasibility study would say it's to explore such and such pit or mine, and at the same time, undertake concentration and refining. That was defined by the investor in their project, in their feasibility study. And that's what defined the scope, as you call it.
Well, we know that is your point of view. But my question was, if the law, you would agree with me that the law defines the scope in Article 83 and so do the regulations in Articles 2 and 22. You would agree with that, right?
It defines the scope in the sense of it referring to the investment project, if that's what you call the scope, but it doesn't refer to the specific project, investment project, or how much is to be invested. That is defined by the investor. They have to say, this is for an investment project. That's what 83 says, and 7 and 11. That is clear. Now, what project, what investment? Well, bring your feasibility study. We'll review it. We'll approve it. And then we'll fix the stability regime. That is what would be done.
But the law defines. You would agree with me that the law defines the scope. So in your view, the law says that the stability benefits apply to investment projects, and claimant has different views. But whatever the proper scope is, you would agree that the law applies. That the law defines the scope of the stability benefits, right?
The law defines that the benefits are for the investment project that is the subject of the agreement and the subject of the feasibility study. That is what the law says. What the claimant is putting forward is a respectable point of view, but that's not what the law says. It's not what the regulation says. It's not what anything says, based on my view, based on my experience, and based on the experience of many persons.
So let me show you. Let me show you. Just give me 1 second. Sorry. We're going to come to the legal provision in a second. Let me show you a statement from Mr. Egiguren, who is the constitutional law expert you were referring to yesterday. And you can tell me whether you agree with him or not. And that is that's a responding expert report number 1, and it's in tab 27. And I'm referring to his first report, which is paragraph 61.
Madam President, according to the rules, the only issues that are supposed to be discussed in cross are matters that are addressed or presented in the witness statement or direct examination. And I don't believe that Mr. Egiguren's report was referenced there.
Mr. Prager will probably have a different view, so...
I do have a different view, because what was discussed in the witness statement is adhesion contracts, and this statement is about adhesion contracts.
Please go ahead.
So we're going to put that on the screen in a second. Maybe a little bit bigger. Maybe we can just pull up the report.
It's English.
No, I think it's his expert report. His expert report, paragraph 61. Can you just pull up the exhibit? It seems so complicated. That's a Spanish version. While we look for the English one. So he says here the content of the agreement, the benefits and the guarantees it provides to the investor, as well as the requirements to access this special contractual regime are predetermined under the law, which is mandatory public, not private law. Consequently, the contractual stipulations do not arise from the free will or negotiation of the parties, or are they subject to the political discretion of the administration or the public officials in office, nor the discretion of the private parties. This avoids potential situations of inequality or discrimination to the detriment of an investor by applying the same requirements and guarantees provided for under the law and incorporated into the agreement for those who meet these conditions. Do you agree with the statement by Professor Giguran, who is
No lo
Peru's
puedo-
expert?
No lo puedo.
I can't see it so clearly. It was clearer before. Just a second. Because you haven't told me exactly where you are.
And the tab was
¿De qué? Plaqueta de qué?
Of which tab number?
25.
25.
Ok. Párrafo
And the paragraph number?
61.
61.
Ok, sí, sí.
So my question was, do you agree with the statement of Professor Egiguren?
It's the same thing that I have said regarding the guarantees, the exact same thing. Moreover, they are provisions. They are supreme decrees. A model contract is a supreme decree, a ministerial resolution. They are legal provisions. It's the same thing. What you don't have is all of the text and the specific figures, because that depends on the moment when the feasibility study is signed at that time. So let me repeat once again. If in 1998 the income tax rate was 30, and if in 2002 it was 40, and you signed in 1998, then you have 30 and not 40. But it doesn't say 30 and 40 in each case in the agreements. It says the regime at the time of the signing of or approval of the feasibility study. That's what it is. It's not subject to negotiation. It's not that the law says 40 and one says, well, I'm going to invest twice as much, I should get a benefit of 35. No, that won't happen. The same thing as Egiguren said, the same thing I'm saying.
Also, just to further clarify that, I asked you about the scope, right? So let's look at what Professor Giguren said when I posed him a question at the SMM hearing. And that's in Claimant's Exhibit 1140, which you have in tab 27. And in the English transcript, that is, I need your help, 2279, 227, and in the Spanish one, if you look in tab 27 of your binder, in the Spanish one, it is 2396, so 2396, lines 21, going to the next page, 97, line 4. So if you look at the bottom of 2396, we're going to put it on the screen in a moment. That's not the... In the meantime, you can look at the tab. We're still finding the right one for the screen. So why don't we just... Oh, is it on now, or? Yes. Okay, so you see I asked ¿Estaría usted de acuerdo, which in English... so I asked Professor Eguiguren. In the English, it's here on the right side, and in the Spanish, you see ¿Estaría usted de acuerdo? I asked, so Professor, you would agree with me that if the mining law says that the scope of the stability guarantees is X, that the parties could then not negotiate that the scope of the stability benefits is something different, is Y? And his answer was yes, in principle that is the case. So would you agree with that statement of Professor Eguiguren?
Well, I don't have it right here, and I don't see it right there, but I have understood what you've said.
Screen.
In the screen is in English.
Okay, we will highlight the Spanish, please. Okay,
Ya,
here we
pero
go.
le he entendido.
But I've understood. I've understood. Well, clearly the benefits and the guarantees are set out in the law. The law says in Article 72, I think, in the single text, and in 2 of 708, it says the benefits and guarantees are this, this, and that. You can read it. It's not negotiable. It's what's set out in the law.
This question specifically referred to the scope of the stability guarantees. So the question that I asked Professor Eguiguren, Peru's expert, was whether he would agree if the mining law says that the scope of the stability guarantees is X, that the parties could then not negotiate that the scope of the stability benefits is something different, is Y, right?
Again, what do you mean by scope?
Well, let's put in the X and Y. So let's take claimant's position, then let's take Peru's position. Let's say if the mining law says that the scope of stability guarantees extends to mining to concessions and mining units, then the parties cannot negotiate a different scope, like they can't broaden or limit it to something different, right?
Bueno, no.
Well, it doesn't say what you've suggested example anywhere. What the law says is that the scope is for defined investment projects, or investment projects defined by the investors in their own feasibility studies with which they make the decision to invest. That's what the state tests and supervises afterwards, applying the legal provisions.
Another example for the X and Y here. So let's take your example. So you say, if the mining law says the scope of the stability guarantees is a specific investment project set forth in the feasibility study, then the parties could not negotiate that. Instead, the stability guarantees apply to an entire mining unit, right? You would agree with that?
No es
That's not negotiable. The law says that it's for investment projects. Well, how could what does the investor want to do? Negotiate something that is outside or different from what the law says? That's impossible. Both would be committing a serious breach.
So I think we agreed that whatever the law says is not cannot be negotiated in the stability agreement, right?
One cannot negotiate the guarantees, nor can one guarantee that negotiate that it's for an investment project or something. That it's not for an investment project or something else. The same answer.
Whatever the law says regarding the scope cannot be negotiated by the parties in the stability agreement, right?
The scope in terms of the investment project to be carried out is defined by the investor. And it's a matter of their own free will. They undertake their feasibility study and they say, this is what I want to stabilize. Agreed. Now, the guarantees for that are these. Those guarantees are not negotiable. The project is defined by the investor. The investor makes the decision. How far do they want to go with the project? That's decided by the investor. Until when do they want to invest? That's decided by the investor. That is what I'm saying.
Okay, so if, hypothetical, if the law said what you say is that it applies to a particular investment project set forth in a feasibility study, is it your view that the investor and the government could agree that instead it would apply not only to that investment project but also to future investment projects that the investor makes in various mining units?
That's not possible. That's not what the law says, and it's not possible. So much so that as soon as the investment is carried out, the project that is subject to stability, well, the counting begins, the time begins to run. And in what I participated in, when I was vice minister, the investment project is this: you carry it out, the meter starts running, and then you have 15 years of stability of what we signed in the agreement for that project. Nothing can be added or changed or anything of the sort. It's that. And that is defined by the project, and the scope of the project is defined by the investor. What's the scope? Well, I'm going to increase production from 30,000 to 70,000, and therefore I'm going to invest so much, I'm going to hire so many workers, and I'm going to install a concentrator. That's the scope. It's defined by the investor. And I say, fine, that's what the rules that we have today are these. I review the feasibility study, I agree, we signed the agreement, and everything is perfectly well defined. I have a question by way of follow-up. You mentioned the concentrator. Now, if it were the original plant and an expansion of the investment, then it wouldn't be covered either? No, it would be an expansion. And not even if there was some correction or adjustment, anything additional would not be covered? It's not covered. What's covered is the original project, and the adjustments are made before the investment is made. And as the law says at some place, I don't remember where, it has to be a matter of clarification, something minor, specification. All those adjustments can be made in the feasibility study, and the any variations in terms of what was invested set out in the feasibility study, one can have make such adjustments only until the meter starts running, when it's finalized. And that's been the practice, that no additional investment is allowed to be covered by stability. So in each contract, when you say, I'm going to invest $215 million, it's going to be 38,000 tons. Tomorrow, I have to invest $50 million more, so instead of 38,000, tons, I'm going to have 38,700. So there's no stability with respect to the variations there. So my question is, if that were the consistent practice, well, the consistent practice, I spent some time, 6 years, so I can't speak of anything else. Here, the fundamental concept is what is defined by the feasibility study. But if you could answer my question, please. I understand that the feasibility study is rigid when it is submitted. That is your position. My question is, anytime a change needs to be made, understanding that mining projects have variations over time, or there are additional investments made and so on, stability was the snapshot taken on the day of the feasibility plan, because I could understand the debate as to whether the concentrator is the same original project. But what you're saying is it's the snapshot at that time and no additional investment, no additional yield is stabilized. Could you let me know whether that's been the practice, and if, in effect, we as tribunal begin to look into the papers, we begin to see that, in effect, any time there was an additional investment, a change had to be made, or it was simply not considered to enjoy the stability, and taxes would begin to be imposed beyond the original project. I'm asking this because it seems to me two different things. One thing is to say the concentrator is a different project. It's another thing to say that that snapshot is immutable. The feasibility study is not a form. It's a document that has a basis, and it's evaluated, and it shows results, and that's why an investment is made and a commitment is made, and the state, for those results, provides general stability. Now, that doesn't mean that if one intended to get 30,000 and you get 32,000, no, it's the same, that you would have to pay more. No, it's the same plant, the same project. If you change the plant, change the project, if you expand it, then you would need to have another stability agreement. So you do pay. If instead of 30,000 you pay, no, I'm saying if it's the same project that you presented and you end up having 2,000 more, then you don't pay. And if instead of 2,000 you have 10,000 or 20,000 or 3 times as much, I don't know of any cases, says the witness. Question. We're speaking in theory to know how it would work. If you ended up with a yield 4 times as much as the original project contemplated, would you pay or not? There is no original project that yields 4 times as much because there are bottlenecks when it comes to obtaining 4 times more. You need investment. Sir, I'm asking if you could answer my question. Well, you've cited an example that would be impossible. What I want to know is the concept. If I got 4 times more, 10 times more, would I pay or not pay? Well, I will answer you with respect to the concept and not the number. The concept is as follows. So long as you stick within the original project with all the characteristics that project has, you make reasonable technological improvements, the costs might go up or down a little bit, and you obtain a percentage, which might happen in practice, then there's no problem. You're going to enjoy stability. But if you say 4 times more, I would say, well, please bring me that person who's capable of doing that. That just simply doesn't exist. So I'm sorry to answer you in this manner, but I can only answer conceptually, and it's not a rigid concept. We weren't rigid, at least. I've never been rigid, but I have been guided by the law and by the principles and what is fair. What is fair is what I stabilize. Well, the result that you might get because of your skill, of your capacity, because not everything is in the book. The feasibility study is a baseline document. But if with that same document or with those investments or with those resources I can obtain more or less, it can be more profitable, welcome. It's a question of efficiency, but not a new investment. If it's greater efficiency with the same resources, then it's no problem. It would enjoy stability. Thank you. I would now like to ask you a question to move from the conceptual level to the reality that we are examining. We find ourselves in the face of a situation in which an investor wishes to make an investment, in this case, for $800 million, which is a very significant sum to invest, and they say that they would like to avail themselves of the existing stability agreement for part of the output. And they even try in writing that if they're granted that expansion, or they seek in writing for such an expansion, the government doesn't respond, but we've seen in what we've been told by Director General Chapuis that she, contrary to your view, maintained that was not the specific investment or the specific project, but rather the mining unit that would be covered. In the future, do you think we need to make decisions about not only whether it's covered or not, but also whether the investor felt deceived because the Director General, who was the one who had to decide, maintains one opinion. And she says, it's different from my boss's view, but this is my view. So to what extent can one speak of deception by the administration in the person in charge of the General Directorate vis-a-vis the investor?
No quiero entrar a temas personales.
I do not want to talk about personal issues because that is not the case. This is not the case, but we're going to talk about those who have the power to do so. The office, the General Office of Mining had granted approval for a specific project. It was not to expand the stability contract or agreement. But beyond that, at the Constitutional Court and also in the draft communique, and she has drafted with me and with Mr. Isasi a ministerial resolution that says exclusively. The word exclusively would not be included if it was going to be for all of the concession. Why would you say exclusively if it is for everything? So exclusively is a portion of it. So it says exclusively from the leaching project. That's what it says. Isasi, Chapuis, Polo, and signed by the minister. It couldn't be any clearer. Thank you very much.
To Dr. Cremades. I heard you testifying yesterday. The ministry, Isasi, Chapuis, myself, the minister, all said that the investment projects that had stability agreements would not have to pay royalties. And as Mr. Cremades just said, we heard Ms. Chapuis testifying the clear opposite yesterday. And as she testified that in a meeting on the 15th of June 2004, the entire ministry, her legal advisors, Mr. Tovar, everyone was clearly taking the opposite position that for Cerro Verde, the whole concession would be covered by the stability agreement. How do you respond to this testimony? Do you know of this meeting? Have you been consulted? So please be as specific as you can be, whether you know some factual background of this testimony.
Let me talk to you about official decisions. First, official decisions are issued by the minister or persons appointed by the minister. And I have seen in one of my statements that I have clearly stated that in Congress, the one who went to discuss the royalty law before Congress was myself. It was not Chapuis or the legal team. So their powers, their area of work is operational, but they do not interpret the contract and see if there was a specific provision. And they are bordering a very serious problem if they said something that I have not seen in writing. What we have seen in writing is what I just mentioned, exclusively for the project, for the leaching project. I said this 3 times clearly before Congress. It is not the company, it is just the project of investment. A concession may have several investment projects, one protected by a stability contract, but the other ones do not have it. The Constitutional Court accepted, not with those words, but they accepted that the only aspect, and I am not a lawyer, this is at 109 of the declaration by the tribunal, the Constitutional Tribunal, and Isasi and myself attended. So they are clearly stating that the rest may be modified, but not the provisions of the contract. They talk about use imperium or the area of the state, because that is more general, and the other one is an exceptional rule to guarantee and promote. So I said it in Congress, and I wish you had the possibility to see the recording of what I said, that it has been cited in my statement. I also said it before the Constitutional Court. One of the members of the Constitutional Court asked me, the concession? No, the investment project. And you can see that throughout my writings, and I was the vice minister. Ms. Chapuy was the director general of mining. She did not have the powers, and none of the ones that you have mentioned. I was the vice minister, and the minister sent me. I had a meeting with the Minister of Economy and also with representative of the legal affairs, my own legal advisor, and we all reached the same conclusion, and I'm sure that the file must include a draft communique that clearly states the same. Whatever Ms. Chapuy has said, with due respect, is not in writing anywhere, is not the opinion of the ministry, starting in 1998, and this is also that Dr. Avila mentioned when he referred to the leaching project stability agreement. So the position, again, this is something that was stated by Juana Menendez, one of the attorneys with the ministry, in a report that clearly states that it is not the company, it is the project. And in one of Juana Menendez's projects, with the signature of Rosario Padilla, and at the bottom it says Maria Chapuy's LVC, and there is a copy of the resolution that Mr. Davenport and Legal Affairs of Cabo Verde had. So they were perfectly aware of the problem.
Referred, if I understand you correctly, to an event where you publicly made this statement that you referred to. Is this mining royalty forum on the 11th of March 2004, where you expressed your position?
Bueno, era el
It was 2004. I don't recall if it was March 11th, but yes, that's what I said very clearly.
Audio recording that we have on the record, right? RE 185.
¿Dónde está acá? ¿Es esto? ¿Aquí? ¿Me puede ayudar, por favor, en qué sitio está?
Would you help me find it? Is it here?
I think he's referring to in front of Congress is RE 185.
185, okay. And I noted that there you stated stabilization agreements are not granted per company, but grant the right to stabilization for that investment. But what was this forum about? I've never attended a Peruvian mining royalties forum, so who was present? Was it the mining society or the companies, or what was this forum about? Was it a public thing?
Yeah. Sí, el público.
Yes, it was public, and it was before the Congress of the Republic. And the Commission of Energy and Mines of the Republic convened a meeting because there was a position within the Congress to apply royalties to everything, to everyone with stability or without stability contract. And I held publicly that investment projects were protected and they would not pay royalties because they were protected by the stability agreement. That is what I held. They wanted for everyone to pay. So I expressed my position, and I clarified also that it was not the company, rather the investment project that was included in the feasibility study that was also the subject matter of the stability agreement. So that is, the protection was for example, leaching. They did not pay royalties, and they should not pay royalties, as well as any other aspect that had a stability agreement. Yesterday, Dr. Isasi told us that Ms. Chapuy and you had well-known differences. Could you refer to those differences? She never told me in my face that she thought that it was the concession. If she had told me directly that she thought it was the concession, I would have respected her position. If she had been certain about it, I would have said first that it was not her jurisdiction. I would have told her that it's not your jurisdiction, or competence, that is my competence and also the competence of the minister. And she was not even following the topic very close. So I do not understand why Dr. Isasi said that the disagreements were well known if she never told you personally. Well, it was known because this topic was addressed, and at some point in time it was not her, the one who addressed it. I think that someone from the ministry was in attendance, and I told him, this is the way it is. And the minister said, wait a minute, Isasi had just arrived. Let Isasi have his own opinion. Yes, but Isasi arrived later, a month later. So what we are trying to know is what was going on in 2004 when the beneficiation concession was requested. So Isasi arrived in July, that was before, but you're saying that the disagreements were well known, but it was already known that she had a different opinion. Well, yes, but I heard that that's what they said it was, but she never told me face to face. And whenever it was said in front of the minister, they didn't get to say the concession. They got to saying that it applied to the sulfide project, but I didn't see it in writing either, but it was known. So the question is, if it was known back then that they were obtaining a beneficiation concession, what did you do? You convene them and say, no, this is not the way it is. Whatever Chapuys or the beneficiation concession told you does not include this. Did you do this or not? This is 2004. The beneficiation concession is different from the stability contract, but you know that Chapuy had a different outlook, and you know that there were conversations with them on the beneficiation concession, or didn't you know anything? Well, you shouldn't talk. So there was no need to talk to me about the beneficiation concession. I am following, please follow the line. I am, but if Ms. Chapuy tells you I have a different vision, so they make the investments, the beneficiation concession is granted. What did you do? You called them and said, watch out, this beneficiation concession does not have this scope. You're not going to be benefited with the royalty treatment. Or did they find this out when they went to Congress? Because this was an investment of $850 million. As Dr. Isasi said, you were aware that there was a disagreement. There are many things, and in this in particular. Let me clarify two things, first of all. The beneficiation concession is not a project, first. It's not $800 million. The beneficiation concession is a request for that expansion, that is to say the right to expand or to build something. The request, a beneficiation concession, no project, and there was no project in mining or with the Vice Ministry of Mines or anything of the sort. And the fact that it was expanded, the fact that they were given the right to transform more is not the project. And the stability project, or the project was never presented as stability project. And this is something that I already said. Official remarks by the attorneys with the General Office of Mining, Dr. Menendez, Dr. Padilla, were clear, and this was endorsed by Mrs. Chapuis and also sent to the company, to Mr. Davenport, and also legal advisors, legal affairs. And the document clearly states that the company is not the one that is benefiting from the stability, but the project. I knew that there was a discussion on that topic and that mining thought about mining, and Chapuis was the lead of mining. And I don't even know what they were thinking, but when I heard that, I said it very clear. No, it's the project. But you didn't think that it should have been clarified with them? As an official, I have an opinion on specific requests. I am not going to go and ask them what they think and what they want to do. That is not my role. But knowing that they were making an investment, and let me finish, knowing that they were making an investment based on what Ms. Chapuis said, you thought that you had to do nothing? No, they were not doing that. They were not doing the investment. They were not making that investment based on what Ms. Chapuis was saying. I am not negligent, as you may be suggesting in your question. So I go out, and I was never, I go out and talk, but I was never asked that. And when you learned that they thought that Dr. Chapuis had said that and they thought it was that way, what did you do? It was never stated that way. They had never presented the project. They had not done anything. And they had not initiated the investment based on Chapuis. Never. They never said that. I knew that mining thought that the project may be included, should have, could have, but not even grounded, because there was no paper. I said because it was clear to me. But it was so clear to you then? It was an important project, yes, of course, and you didn't think it was reasonable to clarify this with them, call them to a meeting and say, if you think that that is stabilized, it's not the case, beyond what Ms. Chapuis may have told you. Well, I don't know what Ms. Chapuis may have told you, but you knew that there were some disagreements. But I don't know what they talked, who talked, and how far they talked. I don't know. Do you need us to repeat anything? I don't know what they talked with Maria Chapuis about. I know that there was an understanding between Ms. Chapuis and Ms. Torreblanca. She was discussing that topic and also saying that that was a possibility. And I don't know if Ms. Torreblanca at one point talked to me and I said that that was not the case. I told her that that was not the case. And then at some point the conversation continued, and it was also stated at an informal meeting. And I said once again what my opinion was. And that was also when Mr. Isasi arrived. He was new to legal affairs. And I said, okay, let's have Isasi look at this. That is what the minister said. And I said, I have no issues. And Isasi got to the same conclusion. So let's have Isasi look at this. But this was after granting the beneficiation concession. No, The beneficiation concession does not mean that that was an investment. That meant that they had the right to expand their possibility for the beneficiation. They had the right. They are two different things. They had not invested one single dollar. They had the right. There is no investment needed. They just need to comply with the requirements. Agreed. Thank you. I would like to go back to the concepts. You had said you didn't want to, but I would like to go back to. On the one hand, the intervention by Mrs. Chapuy and also the intervention later on by Mr. Isasi show us two very different points of view. Dr. Chapuy talked about gossip, and she even went as far as to say that the decision by the Constitutional Court was an unheard solution. So she even questioned all of the legal aspects. And I think that there is a very significant difference between one and the other. And I'm asking you, you're an engineer by training, and you have many adventures in the administrative, legal, and political paths, but you also have this legal knowledge. And I think that Mrs. Chapuy's position is the people from the legal world have no idea, because us, the people who are in mining, do know how this should work. We should look into the contracts, the units, rather than the contract that you had developed as a stability contract. What is your point of view in this situation? What may be maintained as a unit, or quite the contrary? And indeed, the project, as you stated, the investment, specific investment project. Beyond the individuals, that's why I asked you to look into the concepts. The rules, the regulations, as mathematicians, mining engineers, attorneys, to be bound by them. So we are bound by them, and the Constitutional Tribunal is the highest authority as to the Constitution, and their decisions are case law, binding case law for judges and for everyone. So at least in Peru, and a director general of mining, not even a judge, may express or may use their own decisions here. Let us think of the absurd situation of having stability for the mining title holder. A mining title holder, I'm not talking about Cerro Verde, but any, has concessions all over the country. So you are stabilizing the title holder. Some of the regimes are very old, and they were used to pay 45%, and now they are going to sign a stability agreement and apply a retroactivity of the law and now pay 30%? Or even in the future, if the state decides stability for anything that you may do in the future without knowing who will benefit and who will not. From my point of view, once again, I'm not an attorney, but it doesn't make any sense. Beyond this, we looked into the investment project. What is it that the investor is looking for? And this is something that I have been working on my whole life. I specialize in finance and investment projects, economy, and I know what the investor or what the investment project or the investor is looking for. The investor will be investing, let's say, 500 million. So I need to have clear rules of the game. But if you are a promoter, let's say, I give you a stability contract, I reduce the country risk, and I increase the investment rate. I offer you stable conditions in a framework of economic policy that is throughout Latin America and at the same time that is trendy because of the Washington Consensus, and that we also reflected in a series of laws. But this would be, so I stopped being a rock country to become, from the financial point of view, to becoming a country that follows clear rules of the game. I am going to obtain financing, more percentages and lower rates, and reduce the country risk. So what are you going to have? You're going to have attractive return on investments, and your return that I guarantee with a stability contract for that $800 million investment. So you decide, and you do your own feasibility study, and then your shareholders decide. But I do not make a decision. It doesn't make any sense, in my opinion. But you gave us the example. This is a mining unit, and it turns out that in the future, as part of that mining unit, strange rare earths are discovered. We were told that the stability contract also included the stability in connection with the production of those rare earths towards the future. Does that make any sense for an engineer? Because she was talking here as an engineer. I'm also an engineer. So we're going to have a broad view. I'm always trying to have a broad view. If rare earths are part of the mineral that I am extracting, and that's perfect. But if I have to put together a special plant and investment to extract the rare earths and for a different treatment, that is a different project. But if the rare earths are there with the mineral, and the rare earths were seen with that mineral, and that mineral that I may treat through the stabilized system will be defining a concentrate that has a valuable content of rare earths. But the same project, once again, I do not know what I can get from the earth, but what I cannot do is to expand, because I already know that I have rare earth and expect that that would be part of the previous situation. And that's the reason why you have a different stability contract if you want to. Fernando, would you allow me to ask you a question? I thank you, and I also apologize for this ping pong of questions. I have a final question. I have a copper concession, and I need a different technology for copper. And let's say that with that concession, I obtain gold, but it is stabilized. Let me tell you that the concessions are not for copper, they are for metals and non-metals. You may have, if with the same project you get copper, gold is the same. Well, you don't know what you're going to get, it's still stabilized. And that's the way it is. You are going to have a higher benefit, but you will be using the same resources. As long as you use the same resources, we're all happy. Welcome. Creo que vamos ahora a permitir al demandante a que siga el contrainterrogatorio y después tal vez tenga otras preguntas.
I think we can then now continue with claimant's cross-examination, and I may also have some questions at the end.
Thank you, Madam President, and these were very good questions that already hit on a number of the issues I wanted to discuss with Mr. Polo. But let me ask you the following question. You said you're also an engineer. Just to clarify, you're a civil engineer and Ms. Chapuis is a mining engineer. Is that right?
Yes, of course.
And you would agree with me that the investment in the concentrator project at Cerro Verde was the biggest mining investment in Peru in the year 2004, right?
No fue en el.
I don't think that it was in 2004. I think it started in 2004. I was going to leave my post soon thereafter. Well, it was a very important investment, and I was happy that it was made.
Yeah, it started at the end of 2004, and it was completed in 2006, correct? Is that your recollection?
Okay.
I was no longer the vice minister. I left in May '05.
You surely were aware of Cerro Verde's intention to invest in a concentrator, weren't you?
Yes, and I think I don't know if I had discussions at some point in time with Mr. Rodrigo there, and I shared my viewpoint with him. I don't recall exactly. We had friendly conversations, and we had some disagreements as well.
Perdón.
Quick question. You had disagreements on this? I don't remember if it was about this or another project that Mr. Rodrigo was providing legal advice to. I remember that I had disagreements with him about the investment project. Perhaps it was Cerro Verde or Orlando. I don't know. Many years have gone by.
Say, if you go to your second witness statement, tab 2, if you look at paragraph 34, which is
Separador 2.
it's perhaps easier for the witness statements if you look at the small binder where you have both of your witness statements in there, so you don't have to turn so many pages. Yeah, I think if you look there at your second witness statement in paragraph 34. Now, you say, now I would like to note that despite the fact that some Cerro Verde officials were constantly visiting Minam during the 2004-2005 period, and in particular on the eve of the enactment of the mining royalty law, they did not personally consult me about my opinion on the scope of their stabilization agreement. You see that?
Sí,
I do.
Your recollection?
sí.
Yes.
The reason they did not was probably because the DGM, and you would agree with me, right, that the DGM was the responsible body within the ministry for overseeing mining activities, right?
That has nothing to do, overseeing mining activities has nothing to do with this issue. It supervises mining companies in operation. This has nothing to do with the stability agreement, whether this applies to primary sulfides. That's not part of their jurisdiction.
Mining was responsible for ensuring compliance. The Director General of Mining was responsible for ensuring compliance with stability agreements, weren't they?
Yes. For the investments to be made, and it verified that the investments were made with the opinion of the auditor. It looks at them, it approves them, and if it doesn't approve them, there is constructive approval. And then it would supervise and oversee, but that has nothing to do with the stability agreement.
It says in Article 101E.
Excuse me, I would have a follow-up question because I would, and I like to better understand the authorities within the ministry. So, you just described that they were to ensure compliance with tax stability agreements, but this is something completely different than defining its scope, or what was. Can you explain what their authority is when we get here to the heart of the matter?
That's in the law. It is very clear in the law. Articles 85 of the single unified text. The issue is when the feasibility study is submitted to the DGM. The DGM looks at the feasibility study There is an exchange of opinions, there are adjustments, corrections are to be made here and there. When the feasibility study is approved by the DGM, it is sent to the Vice Minister of Mines for the contract relative to the specific project to be prepared. And that's the end of the approval of the feasibility study. Once the contract is signed, then we have to see when the stability period begins to run. And then the company starts making its investment. Let's just say that we ended in 2006. There is an external autonomous auditor that's an expert. He or she certifies this and says, okay, this has met all of the provisions of the feasibility study, etc. And this goes back to the DGM. The DGM has to issue an opinion on the basis of the audit, and it has to say, okay, that's the investment made. That's a process. Okay, then during operations, mining oversight is going to be conducted, and of course, all of the current procedures are going to take place. That's it. You are a civil engineer. I am an administrative lawyer, so my specialty is administrative law. The regulation establishes this. Is there any other provision that establishes specific powers in connection with the stabilization agreements? For example, we have a ministry law in countries like mine that, for example, gets general powers and then details specific powers. So are there any other powers different from the DGM's powers to deal with the stabilization agreements? Well, we have a special law of organization and functions that is approved via a resolution. The stabilization agreement is an exceptional act. It is not regular. The government establishes an exceptional benefit for these cases. Regular things are established in administrative provisions with all the powers, and the powers indicate what the Vice Minister can do, what the DGM can do, etc. And the mining law provides for this itself. At the end of the feasibility study will be sent to the Vice Minister for the agreement to begin. Now, in connection with the powers, here it talks about to ensure compliance with taxability agreement. Is there any other specific power different from the DGM that is related to the tax stabilization agreements? I don't recall, sir. I don't recall. You said that it wasn't within the powers of the DGM. No, it's not their power to approve stability agreements or to modify them or to treat them. Those agreements are entered into by the minister or the vice minister, and that is sent. Those agreements are sent to the central bank, to the Ministry of the Economy. So you cannot really take upon yourself other powers that you don't have. For example, to modify a stability agreement signed by the Minister of Energy and Mines or vice ministers or things that have to do with exchange issues. Those powers are not within the DGM. Now, if you modify the stability agreement, if you're trying to interpret the scope, why is it that that is not within this power to ensure compliance with taxability agreements? Neither the minister nor I can interpret that. That was signed. If we want to make a change, there are procedures to make a change, and that is via contractual amendments. My attorneys, others, have said to me that exceptional aspects within a general provision cannot be interpreted. They need to be exhaustive. I am an engineer, but that is, again, what I understood from what they told me. A third level official cannot take upon himself functions it does not have, much less interpret things that are perfectly provided for in the law. I would say that that is terrible. Why? Because behind all this, you have public funds, right? Imagine if a lower level official changes what higher officials have approved, and their public funds, and then $300 million of taxes are not paid, and that would be great corruption, right?
Do I understand you correctly that it's your position that even if Ms. Chapuis were of the opinion that the concentrator was stabilized, and even if she was of the opinion and would have really expressed it, that the extension of the beneficiation concession would bring the concentrator under the stabilized regime, that this would have been clearly beyond the powers of the Directorate General of Mining as defined in the applicable laws?
That is correct. Her opinion is valuable, it is taken into account, but she cannot do this. And she would be explained that she's not correct. Like I explained to everyone that asked me questions. I didn't impose anything. I provided reasons, I explained things, and I expressed my viewpoint publicly before Congress, before the Constitutional Tribunal, before the Ministry, in writing, in the writings I submitted to ECLAC. Yes, you can follow my opinions. My opinions were public. I haven't seen any public opinions from the DGM, the director, that said that. I'm sure that would pose a lot of problems for her.
What is your view on the scope of powers of the Directorate General? Is it a debatable issue, or is it, in your view, a very clear authorization or lack of authorization stipulated by the law? We have experts on that, and I know you are an engineer, and I can ask the experts, but I just want your personal view.
Her powers are very clear. Her purview is very clear. So clear that she exercised them while I was her boss. She has disagreed with me oftentimes, but always acting within her powers.
Thank you. So finally, I hand over to Mr. Braga.
No, I appreciate very much the tribunal's questions.
Or maybe we should make a break.
We can make a break now.
Yes.
That's fine. Thank you.
Okay, then we have a 15-minute break.
Gracias. ¿Ese no es mejor, Peregrini? ¿Tiene otro para mí?
I think we are ready to start. Mr. Brand, please.
Mr. Bolo, the Vice Minister signs the 10-year stability agreements and the Minister signs the 15-year stability agreements, correct?
That is correct.
Once the stability agreements are signed, it is the Directorate General of Mining's responsibility to ensure compliance with tax stability agreements, as we discussed, right?
The DGM assures compliance with what is established in the feasibility study. That is their function.
As here, Article 101E says the powers of the Directorate General of Mining are to ensure compliance with tax stability agreements, right?
Yes, within their authority. They're not going to verify payment of royalties. That is done by SUNAT. They're going to verify that the investments set out in the investment project are carried out. That is that's the part of the tax stability agreement that corresponds to that.
Compliance with tax stability agreements. So, Mr. Pollitt, to ensure compliance with tax stability agreements, the DGM also has to determine what the scope of the stability agreements is, right?
What the DGM needs to determine is review of the feasibility study and approve it. That is the scope that they review, approve, and supervise up until its approval, that there is a stabilization of the rules, and then they are to see that the feasibility study is, that what is set out in the feasibility study is implemented.
Two parts of it. Reviewing the feasibility study to determine whether it meets the requirements to conclude the stability agreement. We agreed that's also the function of the DGM, right?
It is a function of the DGM to review the feasibility study. I repeat, it is not their function to review the guarantees. That's not their issue.
But to the second part of it, once the stability agreement is concluded, to ensure the compliance with the stability agreement, the DGM also has to determine what the scope of the agreement is. Otherwise, you can't ensure the compliance, right?
The DGM has to pronounce themselves on implementation of the investments set out in the feasibility study that was previously approved, and then to see if they effectively coincide with what was approved. That's it. And once the DGM says the investment has been carried out after the study by the external auditor, then the stability period begins to run for 15 years. That is what the DGM does.
The mining investor makes a new investment and says this new investment is stabilized. It's up to the DGM then to determine whether the investor is correct, whether the investment is or is not stabilized. Isn't that the case?
That is not up to the DGM. Plus, if it is stabilized, it would have to have an agreement, and that is not up to the DGM. That is not the DGM's function.
In your view. So whose function is it, in your view, to make that determination?
First, the signed stability agreements go to SUNAT, and the one that reviews to see to compliance with the tax aspect and other issues that are of the under the authority of SUNAT. It's SUNAT. It has the feasibility study. It reviews exactly what is stabilized, and payments are made based on what's stabilized, not the DGM. The one who reviews exchange rate issues is the central bank, not the DGM. The DGM reviews to make sure that the investments are actually made. Plus, the agreements are a matter of public knowledge. One says, I have an agreement. Where's your agreement? Neither the DGM nor me nor the minister nor anyone can say, in effect, I do think it is appropriate because it's in the agreement, it's the same unit. No one, not even the minister. But if there is an additional investment, the SUNAT doesn't know whether it's in the scope of the original project or not. Who looks at that at the Ministry of Mining? SUNAT receives the feasibility study. It receives the agreement, and attached to the agreement is the feasibility study. The SUNAT has all the information. But you said before when I asked you if there are additional investments and the yield is 2 or 3 or 4 times greater or whatever, insofar as it's the same project, then it would be stabilized. So how does the SUNAT know this? Someone at the ministry has to tell them it's stabilized. Sir, what is stabilized is in the feasibility study, correct? Excuse me, but could you answer my question, please? Because what I said is if there are additional investments and the result is a greater yield, you said that if it corresponds to the same general project, even though it's a greater or new investments, then it's stabilized. So what I'm telling you is, well, the SUNAT doesn't know that. The SUNAT sees that instead of 50 million, they get 200 million. How does the SUNAT know? Who at the Ministry of Mining tells them whether that is or is not within the stability agreement? First of all, I did not talk about additional investments that yielded 4 times the output. What I say, well, what SUNAT has to look at is the feasibility study. The feasibility study defines what's going to be made, what's going to be done. If there are additional investments, then they would have to have a different stability agreement. That's what I say. But that's not what you said earlier. You said earlier that if there are additional investments within the same project, for example, instead of investing 250, we invested 275. And instead of 100 million, that yields 110, 120, 180. You said it's stabilized insofar as it's the same project. Now, let me tell you what the same project means. I don't think we understood. I did one another, or I didn't explain it very well before. One knows what the project is once the external auditor declares it and the DGM approves it. So there you have the project. There's specific projects that are subject to external audits approved by the DGM. That is the project. Now, what I told you is if you have a project, a plant, you have ore, for example, that you found rare earths and you got rare earths, well, that's okay. It's stabilized. But if you tell me that it's 4 times greater, that's not possible. That is just impossible. But who will tell the SUNAT that it's the same project? The SUNAT has the project. And who says that at the Ministry of Mining whether it's the same project? What do you mean by the same project? For example, as Mr. Cremades asked, if you take out a different mineral and you get the same, it enjoys the same benefit, who at the Ministry of Mining indicates that? It's set out in the project. So does SUNAT interpret this without any help from the ministry? SUNAT has the feasibility study. Excuse me. It has the feasibility study. So we're talking about tax-related matters. It has the feasibility study in which there are going to be revenues, costs, and results based on the investment project. SUNAT has that because they have the study. They know what it is. Plus, SUNAT has, according to Article 25 of the regulation, the title holder has to have exhibits showing anything that has varied. And nothing stands in the way of the SUNAT. If it finds something unusual, well, if it takes note of that, then of course they can engage in a consultation. That's obvious. But there is no specific procedure. SUNAT has what it needs. It has the feasibility study, and they have to have the demonstrative appendices, and that's set out in the regulation.
Just again, there are various things that you said that I want to follow up on. The first thing is, if you look at Article 101 in its entirety, which is in tab 9 that you have there, if you look at little c, it says to approve the technical economic feasibility study, which is what you mentioned. That's the technical economic feasibility study that proves that the requirements are being met. Sorry, it's tab 9. Tab 9. 9.
¿En qué parte?
And where is it?
Part C, like Cesar.
Este es el,
We also put it on the screen, but
este es el 9 y es el decreto 0.
This is 9, and this is a decree 01492. It's something else.
that's from the mining law, Article 101 of the Ley de Minería.
Ah, ok.
If you go to Article 101, we also put it on the screen.
Ya.
Okay, so you see, you mentioned approve the technical economic feasibility study. That's is 101C. You see that?
¿Sí?
Yes?
Technical economic feasibility study proves that the requirements are being met to access stability, right?
No es eso.
That's not what a feasibility study does. The feasibility study describes what has been decided upon by the investors themselves, what the project is about. It has to do with increasing from 70 to 100. For that, I require this investment. I need more workers. I need to make use of this technology. I'm going to access.
Bueno,
We disagree on that, but that's fine. And little e, the point I wanted to make is to ensure compliance with tax stability agreements. You see that?
sí, ya lo dije.
Yes, I already said so.
Agreements cannot only mean to prove a feasibility study, isn't that the case?
They have to oversee compliance with the tax stability agreements within the scope of their authority, not outside of it. They cannot invade the authority of ministers. That's clear. You say that I've already said that, but then you're asking me again.
An exchange from the SMM hearing, and that's in tab 3, Claimant Exhibit 1137. And that is in the Spanish 1287. You have it page 1287 to 1288. It's a longer exchange. It starts on line 3 and ends on page 1288, page 22. And in English, it starts on 1259, line 11, and goes to 1261, line 5.
Perdone, ¿en qué pestaña está?
I'm sorry, which tab in Spanish?
Ok. Ya. ¿Qué pasa?
Okay, and where is that?
Put it on the screen in a moment. It's 1287, page 1287 in Spanish, where it says Presidenta Blanche, and it goes to 1288, and in English it's 1259. We start at line 11. So here, President Blanche asked you, so just to confirm, the issue would then be, is it replacement of the same piece of technology, and the fact that it may improve production because it's a new piece of equipment is irrelevant. So the issue is whether it's replacement or whether it's a new technology. Is that how you see the difference? And we were discussing, about what constitutes an investment and what does not constitute an investment that is covered by a stability agreement. So she wanted to, she asked you that question of whether the determining factor is whether it's the same technology or whether a new technology is applied that makes an investment project stabilized or not. And you responded to that after you gave an explanation. You said in English, in addition to that, that is not my specialty. It is not my competence. It is under the General Directorate of Mining that would have to analyze it. So isn't it the case that here in the SMM hearing, you said that to determine what is stabilized and what is not stabilized was not the competence of the Vice Minister, but was the competence of the General Directorate of Mining?
Well, I could never say that. that the authority to see whether or not it's stabilized lies with the DGM. I never would have said that. I understand what you have read, but I couldn't have said that. What I could say is that one could consult on a technical matter with the DGM. What do you think of the nature and impact of that new technology in the project, in the feasibility study that was approved by the DGM? Most likely, I would call the Director General for Mining and say, explain to me, what is this? So I have to use criterion because not everything is etched in stone. A criterion whether to determine whether the technology is completely obsolete. Now, a project is a whole set. Now, if we say that we're going to remove all the technology and then put in new technology, when just a minute, that's another project.
Let me just summarize your question. So what you are telling me here today is that what you told President Blanche of the SMM Tribunal was not correct. That is your testimony.
No,
No, I'm not talking about correct or incorrect. What I'm saying is that I have never said that the authority to see whether something lies within the feasibility agreement lies with the DGM. If that is what I was put down or what was translated, I apologize, but I never could have said that.
The thing is that you were wrongly transcribed? Is that your testimony?
yo no puedo.
I cannot testify as to something about transcription being incorrect or the words not being correct. I don't understand what you said, where you say that at some point in time I say that the DGM has the authority to know and to interpret what is part of the stability agreement, feasibility study, or not. I don't have that. They don't have that authority, and if I said that, then I could not have said that, and if I did, I misspoke. To say that in the scenario where you want me to say it, well, I agree that I might have misspoke if that's what's understood, but I don't understand that. I could not have said that the DGM has authority to interpret the stability agreement because it does not and it cannot. That would be a serious matter. And I've said that on several occasions.
Mr. Bolle, do you want us to listen to the audio to confirm?
Como usted.
As you wish. I have no problem rectifying what I've said if that is the case.
For example, we had a longer discussion about that at the SMM hearing. You apparently changed your mind in the last 3 months. So let's go to, again, tab 3, 1137. This is, in Spanish, page 1266, 12 to 20, lines 12 to 20. And in English, 1239, line 17 to 1240, line 3. And the question here was, so when you were Vice Minister of Mines, you were responsible for executing the 10-year stability agreements, right? Your answer, no. Question, you were not? Answer, no. I was Vice Minister of Mines. Under responsibility, no. Following up on the stability agreement was not part of my function. Do you see that?
Sí,
Yes, that's right. It's not part of my function.
So we are agreed that following up on stability agreements is not part of your function as Vice Minister.
no.
No, unless a point is raised and asking for my opinion, but it's not up to me to monitor the stability agreements. Once they're approved, they take their course, and then they go to the SUNAT. They don't go back to the DGM or to the Vice Minister for Mining or the Ministry of Energy and Mines. And I tell you once again, if you're saying that I've changed my mind over a 3-month period, that's your opinion, not mine.
Is it then to follow up on stability agreements? So whose responsibility within the ministry is it then to follow up on
Los
stability agreements?
contratos.
The stability agreements, once again, once the investment is approved, go together with their studies, the feasibility study and the agreement, go with a copy to SUNAT, and then the company follows the road of the SUNAT, and everything is there. If at some point in time some clarification is needed, nothing stands in the way of them asking for such clarification. They could ask the ministry. If it's a highly technical issue, then I would call the DGM and I will say, what does this mean exactly? And they will tell me, not that it should be granted as part of the feasibility study. That's not within their authority or mine. They will tell me that means this. And I will say, if I will tell the minister, this is my opinion, and I would set it out in writing.
Mr. Polo, can you point me to a provision in the mining law or in the regulations of the ministry that confirms what you just told me? So we can look it up.
Not everything is regulated by law. That is why one must operate with their own criterion. I operate under my authority and with a criterion, not with a list of things.
Say, Mr. Polo, that the application of stability agreements is not regulated anywhere. The responsibility for the application of the stability agreement is not regulated anywhere. That's what your testimony is here?
Sir, please don't change my words. The procedure that is set out in the law and the regulation is clearly established. Stability agreements are signed, they are approved, and the investment is then approved, and that is where the term of stability begins to be counted. Now, those who regulate the guarantees are the competent bodies. If it's tax, it's SUNAT. If it's foreign exchange, it's the central bank. But that is not follow-up. That is simply, I have my agreement, and I apply my contract in my operations. Everything goes forward normally. Not everything has to be precisely regulated. Before I go to the SUNAT, I have to go to the DGM to see that everything's fine? No, that is not the procedure. You go with that document that you have the agreement in hand, and the state answers for each of its institutions, each of them in respect of its own authority.
That an investor who wants to know whether a new investment the investor is making is covered by stability or not has to wait until having made the investment, until the investment is already producing, for SUNA to audit it and then to find out whether it was covered or not by stability? Is that your testimony?
It's my testimony and not yours. I am the one who says what my testimony is. No new investment can go and ask whether it has a stability agreement. If it's a new investment, then you need to have a new stability agreement. It's that simple. I want to make a new investment. I go to the ministry with my feasibility study, and I ask to have a stability agreement. A new investment comes along, and the stability. Is a new investment automatically covered by stability? No, it's a new investment.
Polo, let's come to perhaps it's helpful, to look at a concrete example. And when we look at a concrete example, let's look at the stability agreement that you have signed during your time as a vice minister. And let's take a look at tab 11. That's Claimant's Exhibit 927. And that's a stability agreement with Compañía Minera Milpo. Let's take a look at that. So that's tab 11.
Madam President, again, I have to object because the scope of the cross is to be limited to what is included in the witness statement, and I don't believe there's any reference to Compañía Milpo in the witness statement.
This goes to the essence of his testimony, which is whether stability guarantees apply to an investment project. And I'm surprised to hear that objection from somebody who introduced 10 Ks to witnesses who obviously have never seen them before and who had nothing to do and who did not mention them in the witness statement. So it's not only inconsistent, but it's this goes entirely to the question of what is the scope of stability benefits.
Madam President, he is a testifier
And he signed it too.
He is a testifier of facts with respect to the issues that he has discussed in his witness statements. So and according to the rules, he is supposed to be testifying and having questions asked only with respect to what is included in the witness statements. And the provision is 19.7.3, which is included in Provision 38 of the Procedural Order Number 4, where it says the adverse party may cross-examine a witness on matters that were addressed or presented in the witness statement or during direct examination. This is outside the scope of his witness statement.
Mr. Bolo spent both of his witness statements talking extensively about the scope of stability guarantees, and he walked through all the provisions, not all, but a number of provisions of the mining law and the regulations. That was the very essence of his statement. I'm showing him now a document that he signed while he was at the ministry in order to discuss with him his concrete understanding about the scope of stability benefits.
Well, he
You
didn't
showed Mr. Davenport documents that he never mentioned in his witness statements that had nothing to do with this statement, and that was fine. And now when I showed a witness a document that he signed that goes to the very essence of his statement, you're objecting on it?
Madam President, I'm objecting on the basis of the rules that are provided by the tribunal that were governing these proceedings.
Well, should we strike the questions you gave to Mr. Davenport on the basis of your novel interpretation?
There was no objection in that point, and I am objecting now, and I leave it in the hands of the tribunal. I don't want to have an argument with counsel for claimant right now.
It goes to the heart of his testimony, I would agree, and we have also references to other projects. If he does not know about the project, he will certainly say so.
I will not ask him about any specific facts about the project, but I will take it as a basis to test his understanding of investment projects and the scope of them. So it's not meant to be an exam about the Milpo mine.
¿Voy a hablar? ¿Sí? Ya.
So shall I speak?
Just
Okay.
Confirm that you have found in the meantime the stability agreement for Milpo.
¿Sí? Sí, acá.
Yes.
Just to confirm that, can you look at the signature on the agreement and confirm that you signed it?
Sí, sí, está mi firma.
Yes, that's my signature. Correct. My signature and approvals are there.
A 10-year stability agreement, right?
Yes.
And if you go to clause 1.1, you see it says here, Proyecto de Ampliación Mina El Porvenir. You see that?
Sí.
Yes.
Ask you first of all that question. Does that describe the scope of that stability agreement?
No. In this case, it's a case in which they only need to present the investments they're going to make with a simple description. But the first part of the description is that it's an expansion project.
My question was specifically whether that term that was inserted here in quotation mark and capitals, Proyecto de Ampliación Mina El Porvenir, whether that defines the scope of the stability agreement.
It defines that is an expansion. One will have to look at the investment program presented to figure out the scope. And this is 21 years ago, as I recall.
In your view, the name itself does not, the name that is here in clause 1.1 on its own does not define the scope of the stability benefits.
The stability benefits are something else. It doesn't define the project. Or they're two different things. The project is defined by its content. In the case of 10-year investments, the contents are simpler because they're simpler projects. I don't recall exactly what this expansion is about. At some point it must say what it's about, but here I just have the agreement. And I don't actually remember what the expansion is about.
So it's the content and not the name, the label used here in clause 1.1 that defines the scope. Are we agreed on that?
It's the name of the project and the content and purpose and results sought to be achieved with that project. So the content, well, it's called expansion of the El Porvenir mine. What does that entail? It entails in deepening something or expanding the beneficiation concession plan to obtain such and such result. That's the project, and that's the entire content of the project.
So the project is just the amplification of the mine. It's not it's not the facilities that existed before the amplification took place. Is that what you're telling us?
Of course, the project, which is also to be approved by those who are going to make the investment, entails what the investment is going to be. What's the investment? An expansion. What does the expansion entail? 1, 2, 3, 4. That's the project. And that expansion is the subject matter of the stability. And the part that was not expanded is not part of the stability agreement. It's just the expansion. That's right.
Would you agree that the title as it's, or the name here as it's used in 1.1 itself does not tell us about what the scope of the stability benefits are?
I object because he's already asked this question and he already answered that question. There's no need to repeat it. He already answered.
Well, again, I mean, I don't want to belabor how many times you ask questions twice.
I'm just saying I'm objecting on the basis that this has been asked and answered, and there's no need to continue to ask him the question.
Well, let me ask it differently then. Can I show you a document that Minim sent to Suna that has all the labels of the stability agreements? If you put that up on the screen, that's. I give you in a second. It's step 21. It's Exhibit RE 175. It's taken from Mr. Istas's April 2005 memo. It's coming in a moment.
¿Qué etiqueta es?
It's
What label?
tab 21. Do you recognize the list? Have you seen the list before? Can we do both languages just for?
¿Qué lista es esa?
What list is this?
Aquí.
The one here at 21?
It's a list of stability agreements that I represented to you that Minim sent to Sunat in
Ya,
April 2005.
ya, eso está aquí.
Yes. Is this here?
Sí, ahí está la lista.
Okay.
Yes, I see the list.
Number 24.
Ya,
You find
Yes.
what we just saw, the expansion of the El Porvenir mine. You see that?
Sí.
Yes.
Okay. Now, let's take a look at line 2, for instance.
Centromin.
Centromin?
Promocho, sí.
Mhm. And here the project title is Centromin Peru, right? Is that the stability benefits of the Minera Toromocho agreement applied to the entire Centromin Peru company?
No,
Para Toromocho.
because it is for Toromocho.
And would you agree with me that the title in clause 1.1 doesn't tell us what the scope of the stability agreement is?
Let me reiterate, the titles do not give you the scope of the stability agreement. We need to look into the definitions under the stability agreement as to what the project is based on the definition.
Let's look at the investment project that you say defines the scope of the stability benefits. And in the where do we typically look in a stability agreement to find that, Mr. Polo?
En el proyecto de licitación.
At the bidding project.
Well, let's look at Annex 2.
Me preguntó.
You asked me.
If you could please look
I told you.
of the, we are going back to the previous stability agreement. That was tab 11. So if you go back to tab 11, I know these binders are very difficult to handle.
El 11 que tengo aquí está en inglés.
I have 11 and it is in English. It is in English.
In Spanish.
No, acá hay una resolución.
I see a resolution.
Before the English, you have the Spanish. We don't have the
A ver.
So label 11. I am at label 11. Let's see if there is another 11 around here.
There is a English translation of a couple of provisions as the first sheet, then you find the blue sheet, and after the blue one, you find the Spanish language original. And apologies to the president, the English version is not a full translation of the agreement, but so if you go to Annex 2. You see this on the? We also have it on the screen.
Primero la viñeta es la 11, ¿no es cierto?
It's 11, yes. It's
First you told me it is 11.
of 11.
Ya,
Last
ya.
page of tab 11.
But just that I understand it correctly, because it's in Spanish, we talk about the total investment of 14 million, or?
That's
Yeah.
correct. Yeah, we are talking about the total investment of 14 million. You see that, Mr. Polo? Now you have it. Okay. So
Ya,
is
sí,
that
14.
Yes, 14.
Is that the investment program we should look to that to see what defines the scope of stability agreements?
No, pues el programa de inversión.
No, the investment program is not presented on a page. It is not a page. It is simple, but it needs to have an explanation as to what it includes, what the expansion is, and also from what tonnage to what tonnage it will go. The investments, here you see the list of investments, but it is not just a list. This is not just a checklist, okay? So if we look at the stability contract says more than that, provides for more than that. This annex includes all of the investments estimated to be done.
4.1 paragraph 2 of the stability agreement. It says in Spanish, so that it can be translated into English, este plan de inversiones
This investment plan, duly approved by the General Office of Mining for the signing of this document, is part of this document as Annex 2.
So it is the investment program approved by the DGM, okay?
La Dirección General de Minería.
Yeah.
Sí, es correcto. Es el similar.
It is similar to the feasibility study.
Investment program. It's attached to Annex 2.
Todo el
So
prim-
It is the whole investment program as approved.
Madam President asked, this is for a total investment of $14 million, right? $14,162,600, correct? US dollars.
Ujú.
And because it's for a relatively minor amount, 14 million, it did not qualify yet. It did not qualify for a 15-year stability agreement. It did qualify for a 10-year stability agreement, correct?
Correct.
And if you look at some of the investments here, let me highlight two. One is an access ramp. That's the third one. You see that? A rampa de acceso, translate into English, access
Sí.
ramp.
Yes.
Sí.
Yes.
Let me take one more. It says profundización pique Picasso. A pique is
Sí.
it's like an elevator that goes down the shaft for the workers, right?
Yes.
And it says also development of the lower levels of the mine.
Sí, correcto.
Yes.
Okay, so let's leave Milpo. I'm not going to test your memory about Milpo. Let's take those three as a hypothetical, just to understand. Well, we can still leave that on, but just to understand sort of your understanding. So what you are saying is that that the stability benefits are limited to the specific investments listed here, this $14 million investments, but not to anything else.
Se limitan
They limit themselves to what these investments generate. The results that they generate that will be reviewed by SUNAT within the management areas where the results are produced.
Better understand that a little bit. So if you have a ramp access, so this is,
Okay, I understand.
we keep it hypothetical. I'm not testing about Milpo, but let's say this is an underground mine. People are building a ramp access or extending a ramp access. And trucks are going down that ramp access. What happens to the ore that is being extracted? Is that ore stabilized because the access ramp was extended, or is that ore not stabilized?
The results of that access ramp that will lead to higher production of the ore are stabilized, and that's very easy. You have, prior to the expansion, a result, let's say, of 50. After the expansion, 80. 80 minus 50, 30. 30 is your stabilized amount, correct?
Just the ramp access itself, but the increased output that comes from the ramp access. Is that your testimony?
Claro, o sea,
Yes, the increase of the result is what will be impacted by the stabilization process. That is the increase, not previous results. That's why I'm telling you. Let's say that prior to the expansion, let us talk about the income tax. Let's say that the company, prior to the expansion, paid an income tax of 35. Let's say 35. They invested, they made the additional investment, they expanded, and the contract defined that now the income tax was 25. So the question is, given for the first they paid 35, and for the rest they paid 25. How do you get that to that? Because of the difference in flow. You have the old flows and the total new flows. You subtract and you get the incremental flows. Those incremental flows are the annexes to be presented by the company for SUNAT to know what is stabilized. Okay?
There is also an increment in the production because the already existing production is handled more efficiently. So let's say from the lower levels that you described, there was an increase, it contributed to an increase of 50, but new efficiencies add an additional 20%, and the efficiencies are not related to the investment and investment program. That's stabilized too, or that's not stabilized?
Yo aplicaría.
I would apply, since the increases are due to the investment, once again, I would apply the flow differential. You have given me one of the most complex cases because you're going to say which one is which. You don't need to know which one is which, but you may know it because if the miners know what block they are extracting it from. But which one is easier for SUNAT and anyone? You have the initial flows and you have the flows with the investment. The differential in flows generates everything that is to be applied under the stability contract, and you're giving me one of the hypothetical cases that may be a little bit more complicated. There are others that are simpler, such as the subject matter of this hearing.
Part of the increased output is the result of efficiencies and not of the new investment. In your concrete example, you said the new investment, as you interpreted, added an increased output of 50. Now, increased efficiency at 20. The efficiencies don't come from the investment. Let's say they have a new machinery. Are those 20 stabilized or not?
Yeah.
I understood that the new investment led to higher efficiency, but now you're telling me it is not the case. It's highly hypothetical. Now, let's say that it is difficult, I could say, to differentiate, but it's not that difficult. You need to show SUNAT that this is what the investment does. This is what a company does when they want things to be done correctly. This is what we do with investment. I have included this technology, this technological change, which is a new investment, and I get to this new outcome, and this is the expansion. So you subtract what you get from the technological change that is not here, and you subtract, and the rest belongs to expansion. Now, if you, for the technology change, you had also investments that are not here or anywhere, depending on the scope. If it is changing just one chip for another one, that is not a problem. That's when we use the criterion, and I cannot recall right now here during the hearing and also with this hypothetical, but I have criteria. And I know how to use I have a judgment, and I know how to use that judgment.
The increase of 20 units caused by efficiency, that's something that SUNAT is going to tell me eventually whether that's covered or not. You can't tell me that right now.
Yo tendría que saber qué.
I would need to know what is it that leads to that increase. If it is a change, for example, let's say that there is a new shift system for the workers and you have more production, I can tell you, okay, there is a change in the shift, then there's not a problem, we maintain the old system. But the new investments, what leads to the new investments is here the issue. If that 20% was part of that, then it would be stabilized, and then...
It's again too fast. You mentioned technological changes. So let's assume Milpo, and that's pure hypothetical, Milpo buys new drilling machines that were not part of the initial investments, and mines ore with those new machines, with that new technology from the lower part, right? Now, is that now stabilized or not? Because we understand from the project that the lower parts would be stabilized, and now we're drilling with equipment that's not stabilized. How is that decided?
First of all, I need to establish whether the new machines were here or not as part of this investment project that was, and this was supported or not. If this was here, there wouldn't be a problem. If they were not there, we need to see if it is just a mere change of machines, it is just a current expense, and it is a normal investment.
The new machines were not in investment program.
Well, in principle, the new plant is not stabilized. They're not. Those new plants are not stabilized. But when were the machines introduced? Before, after the expansion? When? I would need to know the details. And you're talking about a hypothetical here.
Let me just repeat the hypothetical again. And I wasn't talking about plantas. I was talking about new drilling machines. They did not form part of the investment program that we're looking at in the hypotheticals. And they are now going with these new drilling machines and drilling the ore from the lower levels. They're using the access ramp that was stabilized. They're using the workers come down with the elevator that was stabilized, but they have these new machines with which they're drilling the ore. That's stabilized or that's not stabilized? The ore that's now mined with the new drilling machines using the stabilized tunnels and access ramps.
O sea, lo que usted me está diciendo.
What you're telling me here is that in this investment I have introduced a new drilling machine that uses all of the stuff that is already here. And that new drilling machine, does it replace the one that you had before? When?
Antes.
Before? After?
It is in force.
Tendría que pensar.
I need to think about it. Clearly, accesses and all that is stabilized, but I need to think about it. The issue has to do with the materiality, with the substance, but I need to think about it. If it is a very important investment, unfortunately, it would not be included. But the problem is how to establish a difference. Once again, the way to differentiate those cases, the ones that you are mentioning that are quite complex for me and that they are hypothetical in between inverted commas, because if the new driller existed when there was no contract, and I understand that it would have been logical for it to be included in the investment plan, but these are investors that are up to date. But this is simple because you have the history of production without the project, with the project, and now with the machine, correct? So basically And once again, this goes back to materiality. Everything that is easily evidenced as part of this investment is stabilized. Whatever is not the subject matter of the investment is not stabilized. Except if the previous drilling machine had a problem and I change it into a new one that is better, well, then it would be just a replacement. It is not a new project. It depends on the circumstances. So if things are not black or white, or they're not just a checklist and a listing, I wouldn't need vice ministers or DGMs. I could probably do it much easier these days, probably with a chat GPT.
I wasn't asking whether the drilling machine itself would be covered or not. I was asking the ore that was mined as a result of the non-stabilized drilling machine. Is that still stabilized? I mean, an investor would need to know that, right? I mean, is that ore still stabilized because they are using the access ramps from the investment program and the elevator, or is that no longer stabilized because they're drilling it now with a non-stabilized driller? It's not that complex. I mean, that's how mining happens, right?
Bueno, usted
Well, you should know. Let's see. The ore, at the end of the day, the machines are not stabilized. Everything that goes with the machine, and that includes the mineral, the ore. If you're having access to new ore, that's a different situation, and it is not part of the project as such. I understand that this is something to be studied thoroughly, carefully, so that we are not unfair with one party or the other. But you're asking me to look into hypotheticals, and this is a project that is not the one that you're not mentioning here, but it could be very similar, and about a way in which I think that something that I saw 22 years ago. Clearly, I was not the only one judging the situation. I always had the assistance of the team, legal affairs. We would also report to the minister, clearly.
New mineral that is not covered. What do you mean with if you access new mineral?
O sea, digamos que esa máquina perforadora.
Let's say that drilling machine allows you to get to areas that were not accessible before. We're talking about the access. The new machine may allow you to have access to areas that you were unable to reach without the new investments. We're talking about different things.
Who determines where the old zone ends and the new zone starts, and how do you account for that?
That is done by the miners because they are familiar with the blocks. And also in the aide memoire to these investments, it's quite likely that they would state this will be applied to this area or the other one. But you would realize, because geologically, the geologists conduct their mining plans with the miners and also their development plans, and they make progress and they keep moving forward, and they constantly have access to some areas and others are not accessible. If with new machine you have access to new areas and you can get more ore, then that is part of a different project. If it is something significant, if it is just changing one drilling piece of equipment for another one, and then I get more out of efficiency, yes, it could also be covered by stability. It depends on the situation. You're asking me to look into a hypothetical situation just by myself. I never work like that.
You're testifying that was your idea to limit stability benefits to an investment project. So you surely gave it some thought. So that's why I'm asking you here. So what if they, are drilling and they'll, it's a zinc mine, right? Zinc and lead mine. But what if they're lucky and strike gold? Is that? And the investment plan doesn't tell us anything about, gold. limited to zinc and lead. So is the gold they find stabilized or not?
It was not limited to zinc and lead. It was defined. There was a mineral area that was going to be acted upon that had defined contents. If you find gold with the same investment, of course it is part of the stability contract. It is, no one may know what you will end up finding, and technology evolves, and for example, price may change. The reserve is an economic, not a physical term. Economic term means that it is related to pricing and cost, and also the economic nature of its extraction. With some economic areas allow us to extract more and also to increase reserves. It doesn't mean that you are going to have more reserves. You're going to extract more. It doesn't mean that each piece of mineral will be stabilized. If I have these resources and with these resources I have a higher extraction, in my opinion, it is stabilized because of accessibility, price, efficiency, but you introduced a new investment, and this investment is materially significant. It is not a replacement with better technology, etc., etc. Then in that case, in principle, it would seem a new investment and also an adjustment with a new feasibility study.
Let's use the hypothetical that there is a non-stabilized plant, right? I mean, let's say they build a new plant that's not stabilized. In your point of view. And the ore that comes from, the stabilized ore that comes from the lower parts is now processed in that non-stabilized plant. Does it then become stabilized or not? Let's say we have like a concentrate afterwards, or is that stabilized or not
Mr. Praga,
stabilized?
can you repeat the question?
Okay, sorry.
Yo tampoco lo he entendido.
Okay, let's assume there's a non-stabilized processing plant, and the stabilized ore that is being extracted from the mine is processed by that stabilized plant. Let's say it's a flotation plant, non-stabilized flotation plant. Is the ore that was stabilized, does it remain stabilized when it's treated in a non-stabilized plant, or does it become non-stabilized as a result of being processed in a non-stabilized plant?
So to begin with, the mineral is not what's stabilized. The project is what's stabilized. I don't know if that clarifies my answer. You stabilized a project with that mineral. You said what mineral it was, what project was going to process it, and that has a stability plan. If that mineral is taken elsewhere, then you are not within the stability agreement. You have a project that uses the resources that are here.
Si usted tiene
If you have a different plant that is not stabilized, you are outside the stabilization agreement.
usted decide
If you decide to take that mineral to the non-stabilized plant, and that would be strange, really, well, things are different. They can process different minerals with different characteristics. I wouldn't want to give an example, but I do have a question for you. After listening to all of these questions that you are posed, these are hypotheticals, but also some of these things are real. Things seem to me they're a bit illogical. There are two things here. First, the technical things, and then you have the tax things that are sent to the SUNAT, and the SUNAT is the one that has to provide an answer. There are institutional inquiries, of course, and the logical thing would be that, okay, if there are doubts, those doubts should be included to the inquiry, rather included in the inquiry to the SUNAT and to the MINEM. Now, these inquiries, are they binding in connection with these technical matters? Must they be answered in writing, and if the questions are not asked, then that's an issue of the investor. But if there are doubts, things have to be asked in writing. Inquiries are very simple. Inquiries do not change responsibilities. The responsibility of the MINEM is to say, okay, what is the project? Is this the project? Is this not the project? And one says, okay, here is the feasibility agreement, the demonstratives. Have you been given those or not? I'm going to explain. So I meet with the team and explain what it is, and I say, okay, this is our opinion. It is not binding unless it is put in writing as a formal opinion in connection with the feasibility agreement. It may be binding, or there may be a responsibility. It may or may not be binding. SUNAT is not an agency that executes things that it is told. So somebody opines under his or her responsibility, and SUNAT acts under its authority and under its responsibility. If there are doubts, they have to consult those that are responsible initially.
So, Mr. Bolo, so you explained that it depends on the circumstances, it explains on the size, it depends on whether it's something significant. You said there are criteria. How do you square that with the purpose of the mining law to abolish discretion?
It would not be a discretionary act. It would have to be perfectly justified. It's not something done under the table. In answer to your question, well, the answer would be no. It is a new investment. Now, if it's a replacement, for example, there is a machine and that broke down and it is old and you replace it with a new one that's more efficient, I have enough reasons to put in writing that you can continue with that machine. That's my opinion, but you would have to talk to other individuals to get confirmation that indeed that is a replacement machine, that the other machine was not working properly, etc. It's not discretionality. To do discretional things has to do with doing windy things. Here, things are in writing, it is well-grounded, and it is stated transparently. I think this, I put in my signature, and I answer.
Well, somebody has, whether it's at SUNAT or within the DGM, is going to have to make judgment calls on what is significant in all these situations that we discussed, on whether a particular asset or a particular production capacity is stabilized or is not stabilized. People are going to have to make judgment calls of what is significant, of what is reasonably still within the investment or not. Isn't that the case?
No. These are not value judgments. These are grounds. If you say that you're going to replace a driller that broke down and that the one that you're going to buy is better and that you're going to be able to do more, that's fully grounded. But if you're saying that you're going to buy a new driller that is not in the list, I said, okay, you have to submit a feasibility study, you have to submit an investment plan, give your grounds, and you're going to get your stabilization regime. That's as simple as that.
Mr. Bolo, can you point me to a provision in the mining law, in the regulations or elsewhere that was in force in the 1990s or first decade of the 2000s that would specifically lay down the fundamentals, as you call it, on how on how an investor can determine what is stabilized and what is not stabilized? Can you Can you tell us what those provisions are?
Sir, when the investor submits the feasibility study, and that is an integral part of the contract, the investor knows that that is stabilized. I don't have to tell anyone to show me something that that person knows about, and they know it's an integral part of the contract. What is the basis of decision of the investor? Well, the feasibility study. The feasibility study has to clearly establish all the resources the investor is going to have to put in to get a certain outcome. The investor knows this. I don't have to tell the investor anything. I approve this, I move this to the Senate, and the Senate applies the provisions. It's not that the investor does not know. The investor knows. It knows what projects are stabilized. The investor has done that. The investor has provided the feasibility study. It has submitted this to the decision-making bodies in the company, the board of directors, etc., and all of them have made a decision on the basis of what the feasibility study includes. Nobody has to tell the investor what goes, what doesn't go. The investor knows.
Mr. Polo, is that the administrative simplification that you try to achieve?
I don't know. I don't know what you thought of this. This has nothing to do with that. It has to do with the responsibility of the company, and what the company does. The company knows what the feasibility study contains, and the ministry has the responsibility to approve this so that it can be the subject matter of the stability agreement. And they know everything.
Make a lot of those determinations. Now I want to show you how SUNAT actually applied stability guarantees to El Porvenir. And that is in
Sorry,
in
Madam
tab
President, I'm going to object
13
because he is
CE
inquiring.
1124.
Okay, so
I'm objecting to the line of questioning. He's going into Senat, which is outside of Mr. Polo's competence. He is here as a minister or vice minister of mines and energy, and he's starting to go into a line of questions dealing with Senat, and this is not his competency.
Mr. Polo just referred us to SUNAT as
Yes,
making
but he's
the,
not-
the determinations. I'm not going to test him on any SUNAT resolutions. I want to, maybe you wait for the question that I ask.
Well, the line of questioning is start to go into what Senat has done. Mr. Polo is here as testifying as Vice Minister of Mines with respect to what he did as Vice Minister of Mines. If there are going to be Senat officials who are coming today, tomorrow, and the rest of the hearing to be able, they can ask questions of the Senat officials with respect to issues in front of Senat. It's not in his competence. He is here testifying as the Vice Minister of Mines.
His competence is the scope of stability benefits, according to him, because he testified in two witness statements extensively on what he believes the scope of stability benefits is. And I am entitled to test that. And I am entitled to test that with by showing him how actually the government applied the stability benefits. That is impeachment. That goes to impeachment. He doesn't have to have written the documents. I'm not testing him on the content of them.
Madam President, he does the issue of Senat and how Senat applies rules in front of Senat are in the competence of Senat officials. We have Senat officials who are here who can testify on those issues. They are the ones who can answer questions about what Senat has done or not done in the scope of their own competencies. Mr. Polo is here testifying as the Vice Minister of Mines about issues about MINEM, Ministry of Energy, and that is what he is here to testify to. And I think it's an inappropriate line of questioning to go down that path with him.
I agree. I think his core competence needs to be tested, but the SUNAT assessments will be covered by 2 further days of witness testimony. So it would be great if you could.
Can I just ask him one question of whether he would be surprised if SUNAT actually applied the stability benefits to the entire unit and did not have to get into all the judgment calls?
Madam
that
President.
To be honest, I think this is so, the particular circumstances of each assessment are so important that it does not be easy also for us to follow. So I think it really goes beyond what the witness needs to testify about.
Thank you, Madam President. So moving, let's just see what we are time with. Moving on, in your, just make sure I didn't leave anything out. In your statements discussing the scope of the stability benefits, you also discussed economic administrative units, and that was, if you look in your first witness statement in paragraphs 29 to 30. Your first witness statement, which is in a small binder of yours. And for us, it's in tab 1.
En la 1.
Behind tab 1?
It is paragraphs 29 to 30.
Okay.
Okay.
Sí.
Okay.
Yes.
And in that statement, you say, I'll just open it as well until it comes on the screen. The Economic Administrative Unit, Unidad Económica Administrativa, or also UEA, is an administrative concept that makes it possible to consolidate several mining concessions into a single unit. And then if you go to paragraph 30, you say you refer to Article 44 of the mining law. You see that?
Sí.
I do.
So the economic administrative unit under Article 44 is enables the investor to combine a number of mining concessions into one single unit. Is that right?
In a single economic administrative unit. Combine the rights. The rights. The economic administrative unit brings together a number of rights to meet certain obligations under the mining law. If you want, we can deal with that later.
In your witness statement, you say mining concessions, right? A title holder of more than, look here in paragraph 30, specifically the law provides to fulfill work obligations, a title holder of more than one mining concession of the same class and nature may group them into UEAs to prove compliance. You see that?
Exacto. Sí, es.
That's exactly right, yes.
Okay. And you would agree with me that Article 82 in the mining stability sections defines a different type of economic administrative unit, right?
Not exactly. If you recall, Article 82, and this came from Legislative Decree 109, well, there it says that for those companies that have projects and that are new and that are over 5,000 MTD, well, they talk about the EAU. So to meet that requirement, they can use all of the concessions. It is a barrier, an entry barrier. So they're included here, those that have more than 5,000 MTPD. So you can include all of the units over 5,000. Yes, so that's what Article 82 says.
82. It is in Claimant Authority 448 in tab 9 in the binder. So look at the second paragraph of Article
Espérese.
82.
Espere, estoy en la...
Just one moment. I was looking at the English.
On the screen, but feel free to look in the binder.
Bueno.
Can you see it?
Okay, very well.
Sí, sí.
Okay.
Yeah, I can see it.
So it says, for the purposes of the agreement referred to in the preceding paragraph, the term economic administrative unit means the set of mining concessions located within the limits set forth in Article 44 of this law, the processing plants and the other assets that constitute a single production unit due to sharing, supply, administration, and services, which in each case the Director General of Mining will qualify. You see that?
¿Sí?
I do.
Es para los fines de los 5.000 toneladas.
That's for purposes of the 5,000 MTPD.
That the way the economic administrative... Well, let me ask you first, let me take a step back and ask you first. This article does not come from the mining reform in 1991, correct? It's not from
No,
legislative
pero-
decree 708, 709.
8.
Oh,
Ocho.
70.
Ya, no
It's 708.
mantiene, pero está...
No, it doesn't come from there, but it comes from all the changes of 708, as you've seen in other articles. Article 2, last paragraph of 708, and also Article 72, last paragraph. It says everything that's current is subject to and the amendments of this provision. 82 cannot be read in isolation.
The reason I asked is I just wanted to confirm you did not draft that provision, right?
82? No, that was drafted before. That was kept from the past.
Is you can have mining concessions that can be within the limits of Article 44, as we discussed, but there are some additional elements. One of them is processing plants and other assets that constitute a single production unit. So two questions. So first of all, it also includes, you see here, it also includes processing plants, correct?
Yes. That's also in Article 9 of the law. These are accessory assets of the concession, and they follow the real property nature, like the concession is redundant together with Article 9.
And processing plants require beneficiation concessions, right, to operate?
That's true.
So the economic administrative unit, as discussed here, includes mining concessions, and it includes one or more beneficiation concessions, right?
The processing plants have an operating permit, which is known as a beneficiation concession, but according to Article 9, it is an accessory asset that follows the concession as a piece of real property. It has the same contents, so to speak. I don't know the details of the law, but although the concession may be outside of the EAUs for all practical purposes, it is considered as part of the realty of the concessioned piece of property.
My question was much simpler than that. I was asking whether under that definition you would agree that an economic administrative unit comprises mining concessions, but also one or more beneficiation concessions.
I'm thinking about that. I never thought about that before. Everything indicates that that's the case. And this because of the principles of Article 9. I'm not a lawyer. I'm speaking from experience and from what I've read and from what I've learned. This issue has never come up. But these are accessory assets. assets that are accessory to the concession, and this is a group of concessions. So all of the accessory assets of the concessions are going to follow the concession under the EAU. And I'm not a lawyer. I'm only basing my answer on my experience.
We're describing the mining law and regulations in ample detail in your witness statement. So if you're not a lawyer, on what do you base it?
Ask another question maybe differently. I understood another witness testifying earlier in this arbitration that the law recognizes not only the economic administrative units under Article 44, but also de facto administrative units, and that Cerro Verde clearly constituted such a de facto administrative unit. Would you agree with that?
I don't know what you mean by EAUs that are de facto. Article 82 refers back to Article 44. That means that there is a space in which you can constitute EAUs. Article 44 uses EAU specifically to say that you can comply with work protection regulations. So, in order not to pay penalties and to say that you're producing and that you have your concession current, you have to produce $100 per hectare per year. What does that mean? Perhaps one of the concessions inside the EAU may meet that $100 and may include all of them, in the sense that the EAU produces $100 per hectare per year out of all of the concessions. So that is the purpose that this has. Article 9, as I said, talks about the assets that are part of the concessions and the accessory assets. The accessory assets are the plans and things that are perhaps outside of the limits of the concession. So if these accessory assets follow the concession, and this is a group of concessions, well, the answer is yes. That is my understanding. This is based on my experience and what I've read, and of what I read. If you want a legal opinion, you have to ask the lawyers. You're asking an opinion.
You answered my question, so please continue.
Thank you, Madam President. The reason I'm asking you is not to get legal advice. The reason I'm asking you is because you spent 3 pages of your first witness statement writing about the Economic Administrative Union. So I wanted to probe that a little bit. I assume you have ample experience with it because you testified on it. So the Economic Administrative Unit, as it's described here, we can agree contains mining concession, but it also says processing plants. A mining concession does not authorize you to have a processing plant. We agreed on that, aren't we?
These are separate concessions, yes.
To have a processing plant, you need a beneficiation concession. I think we can agree on that as well, don't we?
That's correct.
Okay. So, and the additional requirement that it says here, and other assets that together constitute a single production unit due to sharing supply, administration, and services. In your experience, how would you describe a single production unit?
A single production unit is established under a single command system. The superintendents of operating units, and you have their mines, concentrators, a transportation system. It is a set of things that has a specific purpose under a single operational command and under a single production line. That's a single conduction line, rather. That's a production line.
Exhibit So let me show you Exhibit CE 484, which is a minimum communication from you from 23rd February 2005, which is in tab 19. You see that? That's a letter that you wrote to Suna February 2005, correct?
Sí.
Yes.
Agree with the definition in there of a production unit. Is that still the way? I think it was consistent with how you described it before.
Probablemente correcto, no me acuerdo.
Yes, it's reasonably correct. I don't remember this. Someone prepared it. I saw it. I signed it, and I'm responsible for it, of course.
That another way of describing an economic administrative unit, a production unit, is a mining unit, right?
You're saying it would be correct to call it something, to call the production unit a mining unit, or the economic administrative unit a mining unit? I didn't understand.
Let me ask again. So an economic administrative unit is defined as a production unit. Another word for it would be mining unit.
I'm sorry, he's actually testifying right now, so I don't think that's a question. That's a statement of counsel about his interpretation.
There was a question. There was a question mark at the end.
Well, the transcript doesn't reflect that, and the voice didn't reflect it. And my objection is that it was more a statement made by counsel, and
Okay,
it's not a question of the witness. It was a declaration and an argument at that.
Okay, let me ask it again. I'm just sure I have to. So an economic administrative unit is defined as a production unit, and another word for it would be mining unit, correct?
No.
No.
Mr. Polo, can you give us your definition of a mining unit then?
Mining unit or economic administrative unit? Which one do you want me to define?
Yeah, mining unit.
A mining unit is a space where mining activities are carried out that have something in common, such as, well, first, common management, most likely common systems in general. They might have mines, concentrators, and strips, and all of that is a single unit that would be for productive managerial command. They're different things. A single one.
So, just question. The tribunal will interrupt me whenever you want to go to lunch.
How long do you think you will need?
With
for-
Mr. Polo, I would say another hour.
Another hour. So then would it be a good time for a break for you?
I think that would be a good time, yeah.
Okay, then we
Thank you.
have a break. 1 hour lunch break until 5 minutes past 2.
¿Cuánto?
5 minutes past 2?
Okay. Okay.
Okay.